Our topic for today is Republic Act 7080, or an act defining and penalizing the crime of plunder. So let's start with the definition of terms. You have there the definition of public officer as appearing on your screen. That simply means any person holding any public office in the government of the Republic of the Philippines by virtue of an appointment, election, or contract. So that is a public officer. Another important term that you have to remember under this particular penal law is on the definition of what ill-gotten wealth means. So it includes any asset, property, business enterprise, or material possession of any person within the purview of Section 2 hereof, acquired by him directly or indirectly. It would also include through his dummies, nominees, agents, subordinates, and or business associates by any combination or series of the following means or similar schemes. So take note, I underline there the words combination or series. So what are the schemes included? Through misappropriation, conversion, misuse, or malversation of public funds, or raids on the public treasury. It may also include receiving directly or indirectly any commission, gift, share, percentage, kickbacks, or any other form of pecuniary benefit from any person and or entity in connection with any government contract or project, or by reason of the office or position of the public officer concerned. Ill-gotten may also include the following scheme: by the illegal or fraudulent conveyance or disposition of assets belonging to the national government or any of its subdivisions, agencies, or instruments, or government-owned or controlled corporation and their subsidiaries. It may also include by obtaining, receiving, or accepting directly or indirectly any shares of stock, equity, or any other form of interest or participation, including promise of future employment in any business enterprise or undertaking. It may also include establishing agricultural, industrial, or commercial monopolies or other combinations and or implementation of decrees and other orders intended to benefit particular persons or special interests, or taking undue advantage of official position, authority, relationship, connection, or influence to unjustly enrich himself or themselves at the expense and to the damage and prejudice of the Filipino people and the Republic of the Philippines. Now take note that the 6 enumerated schemes or means enumerated that would include or is included in the definition for ill-gotten wealth is not exclusive, because the law even provides or similar schemes. And the 6 enumeration, again, it's not exclusive. Now, when we say combination, either you have their combination of an act under paragraph 1 or paragraph 2, or paragraph 2 and paragraph 3, or paragraph 4 and 5. And when we say series, it could be paragraph 1 only, but it involves more than one occasion. So that makes it a series. So what then is plunder? Section 2 defines plunder, and a penalty is imposed upon the particular offender under Section 2 of the law. Any public officer who, by himself, or in connivance with members of his family, relatives by affinity or consanguinity, business associates, subordinates, or other persons, amasses, accumulates, or acquires ill-gotten wealth through a combination or series of overt or criminal acts as described in Section 1D, in the aggregate amount or total value of at least 50 million. Now, some of you might encounter on the aggregate amount of 75 million. Please do the necessary correction as said amount has been amended already under RA 7659, which was passed in 1993, while this plunder law, the original plunder law was passed in 1991. So the consideration now with respect to the total aggregate of the suspected ill-gotten wealth of a person, you have there at least 50 million pesos. So with that, he shall be guilty of the crime of plunder and shall be punished by life imprisonment with perpetual disqualification from holding any public office. Now, any person who participated with said public officer, remember, it could be committed through his dummy, nominate, associate, subordinate. So if they are private individual, but they are in conspiracy with a public officer, they are likewise liable for plunder because of conspiracy. In the imposition of the penalties, the degree of participation and the attendance of the mitigating and extenuating circumstances shall be considered by the court. In other words, while this is a penal law, it used the nomenclature or the provision provided under the RPC with respect to the imposition of the penalty to the offenders according to his degree of participation, whether he is a principal, accomplice, or an accessory. And take note, mitigating and extenuating circumstances can even be considered if a person is charged for plunder. The court shall declare any and all ill-gotten wealth and their interest and other incomes and assets, including the properties and shares of stock derived from the deposit or investment thereof, forfeited in favor of the state. So again, what is combination and what is series? Combination refers to at least two enumerations provided under Section 1D. Example, raids on public treasury, and it was one act and then another overt act on fraudulent conveyance of asset belonging to the national government, and he transferred it to his name or to his dummy or to his associate. To constitute series, there must be at least two or more overt or criminal acts falling under the same category found in Section 1D, such as misappropriation, malversation, and raids on the public treasury. And it involves two or more occasions of such acts falling under the same paragraph as provided under Section 1D. Who has jurisdiction over the crime? Section 3 provides that unless otherwise provided by laws, all prosecutions under this act shall be within the original jurisdiction of the Sandigan Bayan. Now question, how about those private individuals who were charged together with a public officer? Would the Sandigan Bayan also acquire jurisdiction over them? The answer is a big yes, because the law says within the original jurisdiction of the Sandigan Bayan, and those private individuals were being charged in connivance or in conspiracy with the public officer. Hence, the Sandigan Bayan can also acquire jurisdiction over them. It would have been different if none of the accused or the offenders is a public officer. Hence, the Sandigan Bayan may, okay, that would be a very good question, because the Sandigan Bayan may not have jurisdiction over them, despite the fact that the crime is plunder, and the law says exclusive within, no. It is within the original jurisdiction of the Sandigan Bayan. So that would be a good possible argument. But if you notice this as those enumerated under Section 1D, it involves government funds or property. So it's very hard that no public offender would be in conspiracy to the other offenders, private offenders. And in fact, he is the main, as far as plunder is concerned, he is the main offender. As the definition, to reiterate in Section 2, any public officer, okay, any public officer who by himself or in connivance with members of his family and so on and so forth. So he is the principal offender here. For purposes of prosecuting an offender for plunder, Section 4 provides that it shall not be necessary to prove each and every criminal act done by the accused in furtherance of the scheme or conspiracy to amass, accumulate, or acquire ill-gotten wealth, it being sufficient to establish beyond reasonable doubt a pattern of overt or criminal acts indicative of the overall unlawful scheme or conspiracy. When shall there be suspension or loss of benefits on a person accused for plunder? Any public officer against whom any criminal prosecution under a valid information under this act, in whatever stage and mode of participation, is pending in court shall be suspended from office. Okay, while the case is ongoing, he shall be suspended from office. And this suspension can be considered as preventive suspension because the case is still ongoing. Should he be convicted, meaning to say after trial, he should be convicted by final judgment, the effect or the consequence shall be, he shall lose all retirement or gratuity benefits under any law, but if he is acquitted, he shall be entitled to reinstatement and to the salaries and other benefits which he failed to receive during suspension, unless in the meantime, administrative proceeding shall have been filed against him, because this administrative proceeding is separate and distinct from the criminal prosecution. When shall the crime of plunder prescribe? It shall prescribe in 20 years. However, the right of the state to recover properties unlawfully acquired by public officers from them or from their nominees or transferees, it shall not be barred by prescription, laches, or estoppel. It can be taken back by the government anytime, no prescription. So possible question on plunder. What constitutes plunder? So go back to the definition on what plunder is and who shall be liable for plunder. And when shall the crime of plunder prescribe? So another thing, go back on the definition of ill-gotten wealth. What constitutes ill-gotten wealth? And take note, a combination or series of those acts and the public officer accumulates or amasses ill-gotten of an aggregate amount of at least 50 million pesos, he shall be charged for plunder. That's all for plunder. Thank you for your time.